FE and HE institutions are big consumers of copyright materials and big creators too. Managing these resources requires that those in the front line have a good understanding of what they can and cannot do with learning materials. This may include materials which they have assembled themselves from somewhere, or perhaps have inherited from someone else. To begin with, it is important to have a good understanding of the exceptions which the law contains for those working in teaching and learning. Jackie Milne now tries to clarify and simplify the practical application of these education exceptions.
Some education exceptions, how do they work? Much of the copying which takes place in the FE and HE sector is with the permission of the copyright owner, usually through a licence. However, the Copyright Designs and Patents Act permits certain uses of copyright works to schools, colleges and universities. These education exceptions are useful for tutors and students to know about and take advantage of. If what you want to do falls within an exception, you don't have to get the rights holder's permission in order to copy. But these exceptions are on the whole fairly narrow. There is no universal all-encompassing exception for educational use, unfortunately. Any copying must be fair and reasonable to the rights holders. It's important to remember that just owning a copy of a copyright work does not mean that you can do what you like with it. Sometimes more than one exception may apply to the use you're thinking of, and an exception can be overridden by a contract or license which might limit your ability to do things that you may have been able to do under an exception. At the heart of these exceptions or defences is fair dealing. So what is fair? This is an objective test by the courts. A person who honestly believes what they're doing falls within the fair dealing defence, while important, is not the issue. Rather, the court will focus on the likely effects on the rights owner. Fair dealing is an exception to copyright infringement, where a copy can be made of a literary, dramatic, musical or artistic work for an individual's private study, research and genuine criticism and review. It must be for non-commercial purposes and is subject to an acknowledgement where possible. Criticism and review applies only to works that have already been made publicly available. In order to consider the fair dealing defence, a substantial part of a work would need to be copied. So what is substantial? This relates to the amount being copied, but also the significance of the material. Any copying must be reasonable and appropriate, and it's important to be aware that even very small parts of a copyright work may count as a substantial part. The more substantial something is, the less likely a fair dealing defence will be available to you. Essentially, a fair dealing defence is only available for individuals. So, let's say we're in a geography class. A map is available online, but the tutor can only direct students to it. They cannot ask them to print it. The student must make the decision to do so as part of their own private study. Multiple copying is not permitted under fair dealing, so a tutor putting something on a VLE, for example, wouldn't be covered here. The copying must be for non-commercial purposes. Although a college or university may be a non-profit organisation, if anything is copied for commercial purposes or making a profit, it will not be covered by the exception. Commercial research, spin-off companies and so on are therefore likely to be excluded. There are limits to fair dealing which should be adhered to. As a general rule of thumb, this is 1 chapter or 5% of a book, or whichever is greater, 1 article from a journal and so on. For more information on this, have a look at the JISC Legal website, which has more detail on where fair dealing may apply. Another exception relates to examinations. This has a wider range of use. The exception is restricted, though, to those giving and receiving instruction and can only be for examination purposes. It can extend to any piece of assessed work, not just formal sit-down examinations, but if the examination is just one of the purposes of the copy, then you may have a problem. It covers summative assessment where that piece of work counts towards the final grade. Formative assessment will not be covered by this. Online exams or assessments would apply too. So, if the OS map in the geography class was part of an exam, it could be uploaded even without a licence onto a VLE, where the questions and answers with acknowledgement can be included. Let's say the assessed work was to create a web page that includes copyright work. This would be permitted under the examination exception if only available to the assessor. If the page is made available to any sort of wider audience, for example other students in the class, then unless their comments form part of the assessment mark, the work would not be covered and you would need permission from the rights holder to include it. Remember, you can't use this copied content later for a different purpose. So, to use previous exam questions for past papers would not be covered. Another exception is that of incidental inclusion. This, as the name suggests, is where something is included without intending it to be so. It applies to artistic works, sound recordings, films or broadcasts. Incidental inclusion of such works does not infringe copyright and a resulting work may be shown or played to the public. This will be particularly useful for filmmakers or photographers, so a video being shown where there happens to be a piece of art on the wall in the background would be covered. If a work is planned to appear, then it must be cleared with the rights owner. Be careful if musical works are included, as this must not be deliberate. Equally, if a work could not be excluded, for example, music's being played at a football match while reporting the event, or perhaps listening to a commentary, it would probably be deemed to be incidental. A court is likely to consider all the circumstances of a case, including why the material is being used. If this is for a commercial purpose or its inclusion is essential, it's not going to be incidental. To perform, play, show a work can be an exception or defence to copyright infringement in certain circumstances. Students and staff can perform, play or show a work where that takes place on institution premises, but this cannot be shown or communicated to the public. A performance before an audience of staff and students is permissible, provided the performance is given for the purposes of instruction and is on the institution's premises. If a college or university hosts a performance of a play for other persons, for example members of the public or even potentially parents, without consent from the copyright owner or a licence, this would be a copyright infringement. Where money is generated, care needs to be taken, as any performance must be for non-profit. So you can show commercial videos for teaching or instruction, and any limits, for example for home use only, can be ignored, provided the audience is students and staff only and it's for the purposes of instruction. The exception concerning media studies is a limited one. If you're working in the Media Studies department, you can use materials relevant to making films or soundtracks. Mr. Kent, a lecturer, is teaching a class specifically how to make soundtracks. He uses a commercial soundtrack in his class to review how good it is. This would be permitted. However, Mr. Smith is teaching a language course, could not do this, as he is not teaching about the making of films or soundtracks specifically. You may come across the term fair use applied to copyright protected works, especially on the web. Don't be fooled. This is a term from America, the US. It's not one that applies in the UK. We don't have anything nearly as wide. Without permission direct from the rights holder, an exception may be relied on, but remember, these don't offer a free rein to copy. They are restricted.